The gavel came down with a crack that echoed like a gunshot in the stunned silence of the 15th floor courtroom. For a moment, the only sound was the retreating footsteps of the former president's legal team, their chairs scraping back as they strode in unison toward the heavy oak doors. At the defense table, Donald J. Trump sat alone, an isolated figure in a dark suit, his eyes fixed ahead as the weight of the unprecedented spectacle settled over the room. Judge Juan M. Merchan, his face a mask of controlled fury, did not raise his voice. Instead, in a tone of glacial calm that carried more threat than any shout, he ordered the bailiffs to seal the exits. "This courtroom is frozen," he declared. "No one will leave until I understand the meaning of this contempt." In that suspended instant, the very foundations of American legal tradition seemed to tremble. A coordinated walkout by a defense team in the middle of a historic criminal trial of a former U.S. president was an act of procedural insurrection without modern parallel. It was not merely a dramatic courtroom stunt. It was a deliberate collision between political power and judicial authority, broadcast to a polarized nation and a watching world. The scene, described by veteran court observers as utterly surreal, transformed a complex trial on charges of falsifying business records into a stark tableau of constitutional crisis. This was no longer just about ledger entries or hush money payments. It had become a raw test of whether the institutions of justice could withstand the overwhelming force of a political movement that increasingly frames legal accountability as persecution. To understand the magnitude of this rupture, one must return to the origins of the case itself, which many legal scholars initially considered the least consequential of the 4 criminal indictments facing the former president. The charges, brought by Manhattan District Attorney Alvin Bragg, allege a deliberate scheme to conceal potentially damaging information from the American electorate before the 2016 election. At its core, the prosecution argues that payments to an adult film actress were illegally logged as legal expenses, a business records violation elevated to a felony by its connection to an underlying conspiracy to undermine democratic processes. For months, the defense has labored to frame the case as a politically motivated witch hunt, a narrative that has resonated deeply with Trump's base and provided a template for attacking the legitimacy of the judicial system itself. The presiding judge, Juan Merchan, is a seasoned jurist known for a methodical, no-nonsense approach, more accustomed to the gritty rhythm of Manhattan criminal justice than the blinding glare of global media scrutiny. His management of the proceedings has been characterized by legal experts as meticulous and fair, but increasingly firm in the face of what he has described in rulings as volatile rhetoric from the defense camp. In the weeks leading to the trial, he issued a narrowly tailored gag order prohibiting attacks on court staff, witnesses, and jurors, an order that has itself become a secondary battleground. The defense's strategy, analysts note, has appeared to operate on 2 parallel tracks: a legal argument presented in court and a political narrative amplified in the media, a duality that created mounting tension within the courtroom's formal constraints. Historically, the American courtroom has been a sacrosanct space where even the most powerful defendants are expected to submit, however reluctantly, to its rituals and authority. The circus-like atmospheres of trials for figures like Al Capone or O.J. Simpson tested boundaries, but the procedural framework held. What distinguishes this moment, according to historians of legal politics, is the defendant's unique position as the presumptive nominee of a major political party, actively campaigning from the courtroom and wielding unprecedented influence over public perception of the judiciary. This fusion of campaigning and adjudication has created a pressure cooker, with the judge tasked not only with administering justice, but with safeguarding the very appearance of the court's integrity from relentless external assault. The walkout did not emerge from a vacuum. It was the culmination of a series of escalating confrontations over evidentiary rulings, witness testimony, and the judge's enforcement of the gag order. Earlier in the week, Judge Merchan had held the defense in contempt for a series of social media posts, fining them substantial sums and warning that further infractions could lead to incarceration. The defense attorneys, in filings and in sidebar conferences, had protested with increasing heat that the rulings were unfairly constraining their client's political speech and his ability to mount a robust defense. Sources close to the team describe a mindset of feeling backed into a corner, believing that dramatic action was necessary to protest what they characterized as a kangaroo court atmosphere, a term one attorney used in a tense exchange just hours before the walkout. Outside the courthouse, the political reverberations were immediate and intense. Supporters of the former president, gathered in their usual clusters, erupted in cheers as news of the walkout filtered out through surrogates and live streams, hailing it as a brave stand against a corrupt system. Opponents expressed horror, decrying it as the final collapse of respect for the rule of law. On Capitol Hill, congressional allies launched into fiery speeches, promising investigations into the judge and the prosecution. The partisan divide was not merely reflected in the reaction, it was the essential fuel for the confrontation. The courtroom strategy and the political narrative had finally and explosively merged, leaving the judge with a dilemma for which there is no clear precedent in the annals of American jurisprudence. Inside the frozen courtroom, the air was thick with a palpable sense of dread. Jurors whose identities have been protected with extraordinary measures stared straight ahead, their faces carefully blank, though one was observed repeatedly tightening her grip on a notebook. Prosecutors from the Manhattan DA's office remained seated, exchanging brief, stunned glances. They had anticipated vigorous defense, even obstruction, but not this outright abandonment of the process. For a full 7 minutes, the silence held, broken only by the hum of the climate control and the faint sound of protest chants from the street below. Judge Mershang conferred in whispers with his clerk and court reporter, presumably discussing the immediate procedural and security implications of the defense team's exit. The legal consequences of such a walkout are severe and largely unambiguous. By voluntarily leaving during proceedings, the attorneys likely waived their client's right to be present for that portion of the trial and potentially opened themselves to sanctions for contempt, disqualification from the case, and reports to bar disciplinary committees. More critically, they placed their client in peril. A defendant has a constitutional right to counsel, but not to counsel of their choice if that counsel deliberately flouts court orders and disrupts proceedings. The judge was now presented with a limited and stark set of options. He could adjourn for the day to allow for cooler heads to prevail, appoint standby counsel to represent Trump for the remainder of the day's testimony, or declare a mistrial based on the defense's actions, a move that would likely be seen as a victory for the defense's strategy of disruption. When Judge Merchant finally spoke, his words were measured and carried the full weight of his office. He addressed the empty space where the defense team had sat, and then turned to the former president. Mr. Trump, your attorneys have, by their actions, voluntarily absented themselves from these proceedings. You retain your right to be present, but the trial will continue. I am appointing a member of the court's attorney panel to serve as your interim counsel for the remainder of today's session to ensure your rights are observed. The announcement sent a fresh wave of shock through the room. The appointment of a so-called lawyer of the court for a former president was a humiliation and a masterstroke of procedural authority, reasserting control by relying on the system's own mechanisms. Trump's expression darkened, but he remained silent, a testament to the advice of his now absent team, or perhaps his own recognition of the precipice he was on. The broader context of this confrontation extends far beyond the Manhattan criminal courthouse. It occurs against a backdrop of profound global anxiety about the stability of democratic norms and the resilience of institutions designed to check power. From Europe to Asia, allies and adversaries alike are watching, analysts confirm, not merely for the legal outcome, but for the strength of the system's immune response to such a direct attack. Autocratic leaders have long mocked Western democratic pretense, pointing to political divisions as proof of hypocrisy. This spectacle, a walkout meant to delegitimize the process, provides potent propaganda fodder, suggesting that the American system is too fractured to hold its own leaders accountable. The trial is thus a proxy for a larger struggle, one where the defendant's strategy aligns, wittingly or not, with the interests of foreign actors who benefit from diminished U.S. moral authority. Expert analysis of the defense's calculus suggests a high-risk gambit designed for an audience of one, the court of public opinion, and specifically the former president's political base. This is not a legal strategy in any conventional sense, explains Dr. Elena Carter, a political scientist specializing in legal institutions. It is a performative act of martyrdom. The goal is to create an iconic image of defiance, the lone president abandoned by his lawyers, persecuted by a biased judge. The potential legal downsides, including damaging their client's case, are seemingly outweighed by the political capital to be gained from this narrative of righteous resistance. This fusion of law and political theater creates a nearly insoluble problem for the court, which must operate within its traditional rule-bound framework while being used as a stage for a postmodern political campaign. Insiders within the judicial system express deep private concern about the long-term collateral damage. A senior court official, speaking on condition of anonymity, stated, "We've weathered high-profile trials before. The system is built to withstand pressure, but this is different. This is a deliberate effort to infect the public with the idea that the process itself is corrupt." When officers of the court actively participate in that narrative to this extreme degree, it strikes at the very heart of what allows a society to resolve its disputes peacefully. The worry is that this event will not be an anomaly, but a blueprint, encouraging further erosion of procedural norms in other cases involving politically contentious figures at both state and federal levels, effectively politicizing the bench in ways that may take a generation to repair. The immediate consequence within the courtroom was a day of profoundly awkward and disjointed testimony. The court-appointed attorney, a seasoned and respected criminal defense lawyer with no prior connection to the case, performed his duty with professional detachment, cross-examining the prosecution's witness on narrow technical grounds. His presence, however, was a constant visual reminder of the rupture. Trump, stripped of his chosen advocates, appeared subdued, occasionally passing notes to the new attorney, who reviewed them with a poker face. The testimony proceeded, but the drama of the morning had irrevocably shifted the trial's trajectory. The facts of the case were suddenly secondary. The central question had become whether the trial itself could survive the forces arrayed against it. Political consequences are already cascading through the election campaign. The Biden campaign, after a period of cautious silence, issued a statement emphasizing that no one is above the law, a message aimed at reinforcing the principle rather than engaging in the day's theatrics. More significantly, undecided and independent voters, according to early polling analysts, are reacting with a mix of exhaustion and deepening concern. For some, the walkout is seen as proof of Trump's disruptive, norm-shattering nature. For others, it confirms a belief that the system is indeed weaponized against him. This further polarization hardens the electoral battle lines, making the election a referendum not merely on policy, but on the fundamental acceptance of legal accountability for presidential actions. Internationally, the reactions from allied governments are muted in public, but deeply anxious in private. Diplomatic cables, described by a source within the State Department, indicate intense behind-the-scenes queries about the stability of the U.S. political system. Our partners are asking, with genuine worry, what happens if a major candidate is literally fighting the courts while campaigning, the source said. They need to plan for multiple scenarios, including potential constitutional chaos around Inauguration Day. Adversaries, meanwhile, are leveraging the chaos. State-backed media in Russia, China, and Iran are running continuous segments framing the event as the collapse of American democracy, using it to justify their own authoritarian models and to sow discord among U.S. partners abroad. The walkout also raises grave questions about the future of the legal profession. Bar associations are now under immense pressure to respond to what many see as an ethical breach of the highest order. While vigorous advocacy is encouraged, abandoning a client mid-trial and deliberately disrupting proceedings likely violates multiple rules of professional conduct concerning competence, diligence, and respect for the tribunal. This is a line that simply isn't crossed, remarked a former president of the American Bar Association. It's a betrayal of your client's best legal interests and a betrayal of your duty to the court. The disciplinary response will be closely watched. It will signal whether the profession believes its own rules can withstand political pressure. The defense attorneys, in subsequent statements, argued they were compelled to make a stand against judicial overreach, framing their actions as a necessary defense of constitutional principles. As the trial adjourned for the day, the immediate question was whether the original defense team would return. Judge Merchan ordered them to appear before him the following morning to show cause why they should not be held in contempt and removed from the case. Trump, upon exiting the courthouse, delivered a fiery statement to waiting cameras, lambasting the judge as a tyrant and praising his lawyers as patriots. The dichotomy was stark: outside the political rally, inside the somber machinery of justice attempting to repair a breach. The two Americas, increasingly separate and mutually incomprehensible, were on full display, their divide now literally enacted within the walls of a criminal courtroom. Looking ahead, several scenarios are possible, each fraught with risk. The most likely, according to procedural experts, is that Judge Merchan will impose severe sanctions on the attorneys, significant fines and a formal reprimand, but allow them to continue under the strictest possible warnings, avoiding the delay and chaos of integrating an entirely new defense team. However, this risks appearing to reward bad behavior. A second scenario involves disqualifying the attorneys, which would trigger a lengthy adjournment as new counsel gets up to speed, potentially pushing a verdict past the election, a result that would plunge the country into unprecedented uncertainty if Trump were to win. A third, less probable scenario is a mistrial declaration, which the prosecution would vehemently oppose and which would be seen by many as the court surrendering to intimidation. The risks to the social fabric of the United States cannot be overstated. Legal scholars specializing in democratic erosion point to moments where the failure of institutions to manage conflict leads to a downward spiral of recrimination and violence. This is a stress test of the highest magnitude, notes constitutional historian Professor Michael Lyle. The court must assert its authority without appearing tyrannical. The political system must absorb the outcome without fracturing, and the public must, in some broad sense, accept the legitimacy of the process, even if they disagree with the result. The walkout is designed to make all three of those objectives impossible. The coming days will test whether the centrifugal forces of populist politics can be contained by the centripetal force of institutional procedure. Furthermore, the incident sets a dangerous precedent for state-level proceedings. The former president faces 3 other serious criminal indictments in federal and state courts. The teams in those cases will have watched today's events closely. While judges in those jurisdictions, particularly the federal judges in Washington, D.C. and Florida, run tighter courtrooms with different procedural rules, the temptation to employ similar tactics of disruption will exist. The success or failure of Judge Merchan's response will serve as a playbook for both sides. A perception that the walkout worked, that it delayed proceedings, shifted public opinion, or intimidated the court, could embolden similar actions, turning courtrooms across the country into theaters of political war. The global impact on justice itself is more subtle, but no less profound. For decades, the U.S. has supported international tribunals and rule of law initiatives abroad, often urging other nations to respect judicial independence. How can we lecture anyone about the separation of powers or respecting court rulings after this? Lamented a senior European diplomat involved in rule of law projects. The visual of lawyers walking out of a trial of a former president is devastating. It gives a green light to strongmen everywhere to defy their own judiciaries, claiming they are merely following the American example. The soft power erosion is immediate and tangible, undermining efforts to hold human rights abusers and corrupt leaders to account on the global stage. In the longer term, the event will inevitably influence judicial appointments and the perceived role of judges. The already fiery debates over confirmations will grow more intense, with candidates scrutinized not just for their jurisprudence, but for their perceived ability to withstand political pressure and theatrical disruption. The ideal of the impartial, robe-wearing arbiter may give way to a preference for judges seen as political warriors in their own right, a development that would fundamentally alter the nature of the American judiciary. The walkout, therefore, is not just an event in a single trial. It is a potential catalyst for the full politicization of a branch of government designed to be above politics. As night fell on the courthouse, the scene outside remained tense, with heightened police presence separating rival groups of protesters. The news cycles dominated by analysis, outrage, and speculation. Inside the judge's chambers, it is understood that Mershon and his staff were engaged in intensive consultation with New York's judicial administration and security officials. The decision he makes in the morning will be one of the most scrutinized judicial rulings in American history, parsed not only for its legal soundness, but for its metaphysical weight. Does the rule of law still bind a political movement that questions its very legitimacy? The answer will resonate far beyond the verdict in this case. The strong closing must acknowledge that this explosive turn has forever altered the landscape of American politics and law. The trial continues, but its purpose has been transfigured. It is no longer merely a quest for a verdict of guilty or not guilty. It has become a live autopsy of the American system's capacity for self-preservation. Every ruling, every objection, every day of testimony will now be viewed through the lens of this rupture. The walkout was a calculated bet that the institutions are too brittle to hold. The judge's response and the system's ability to see the process through to a legitimate conclusion is the rebuttal. In the end, the deepest impact may be on the collective psyche of the nation's legal and civic culture. A boundary once thought inviolable has been breached. The solemn theater of the courtroom, where dissent is channeled into respectful procedure, was exposed as vulnerable to the same forces of performative nihilism that have reshaped politics and media. Restoring that boundary will require more than sanctions or rulings. It will require a reaffirmation by a weary and divided public that the slow, boring, and rigorous administration of justice is preferable to the thrilling spectacle of its demolition. The frozen courtroom awaits its thaw, but the chill that has settled over American democracy may prove far more enduring.